question then focuses on the reciprocal enforcement of foreign judgment related legal framework and see whether we have a proper legal approach. Why? International market demands effective options. Commerce depends on options, openness, creativity. If our legal framework does not respond to the changing world, then it may hamper the development of international trade. Not some developed countries who take effective measures, but countries like developing countries like Sri Lanka. We need to look at that issue not only from the economic perspective, but also from the perspective of legal framework. So keeping that particular reality we are now encountering and facing, my research, of course, was designed to highlight some positive elements to justify that. Yes, by bringing some reforms, we can develop the reciprocal enforcement of foreign judgment-related legal framework. First one is theoretical underpinning. Of course, theoretical underpinning is one area we can see. There are writers who have advocated attention to this particular area. Otherwise, it may affect the enforcement mechanism developed within the framework of New York Convention. Second one, of course, there are no hard and fast barriers in the existing international commercial arbitration legal framework. For example, party autonomy. Whole concept of arbitration is based on party autonomy. It starts with party autonomy, ends up with the public institution. If the public institution is not properly regulated by means of law, it can be hampered, yes, undermined. Then the definition of arbitral award. Definition of arbitral awards in the international commercial arbitration legal framework does not necessarily bar the enforcement of a foreign arbitral award based on a foreign arbitral award. Third one is the grounds on which a foreign arbitral award can be challenged. Yes, I referred to the literature and found that there are writers who have advocated and highlighted and justified that grounds for challenging the enforcement of a foreign judgment is more lenient than grounds that are recognized for challenging the enforcement of a foreign arbitral award. Of course, then it can be taken as a positive element. Then the Article 7 of the New York Convention, which also promotes or allows parties to the convention to make their own enforcement mechanism for the enforcement of foreign arbitral awards. Of course, one example is our Arbitration Act in 1995. It responds to the New York Convention and it has a mechanism. But additionally, we have another mechanism, that is 1921 Reciprocal Enforcement Related Statute for the enforcement of foreign judgment. So we need to look at these two particular areas and see whether how can we harmonize these particular legal frameworks. Then only we can go and expand another option for the enforcement of foreign arbitral award for the business community. And the last one, of course, the positive features we can see in the foreign judgment enforcement related legal framework. It is, as I said from the literature, lenient grounds incorporated in the law. Second one, they don't challenge the merits of the case and try their best to and provide a positive legal framework for the judiciary of a particular country to enforce the foreign judgment. And it promotes the concept of reciprocal contractual relationship. Reciprocal contractual relationship can be used as a tool to regulate this particular area favoring the international commerce. Why? We know Hague Convention 1971, which is a convention on the recognition and enforcement of foreign judgment, which has some problems. Internationally, we can't. The drafters have not achieved positive outcome. Regionally, we have, but it is limited to the parties to the region. But nationally, we have another framework that is based on the reciprocal enforcement of foreign judgment-related legal framework, which promotes concept of reciprocal treatment or reciprocal arrangement that can be done between two parties. Of course, it has some positive strength, which we should look at that and make use of it for the for identifying or rectifying the problems we can identify in this particular area. So this is the preliminary investigation. These are the findings, of course, I found from the preliminary investigation. My research, of course, includes another part in which I am going to discuss in detail some areas which we need to reform. For example, definitional issues which creates from the reciprocal enforcement related legal framework. Second one is the scope of the reciprocal arrangement. And third one is the code, the national code, whether we should develop a proper infrastructure for that particular purpose. So by highlighting those particular issues which need and which deserve in-depth study, so my research is purely mainly based on qualitative basis, and findings are based on those qualitative information. Of course, given the reasons such as commercial needs, given the problems we can see in the internationally recognized conventions applicable to this area, and given the contradictions we have created between the New York Convention and the other enforcement of foreign judgment, which can undermine the highly recognized, highly effective New York Convention in 1958. So keeping those things in mind, of course, I want to justify in substantiating my argument, we need close attention, as Rob said, to bring more amendment and produce a better outcome. Thank you very much.